How does travel impact your green card? My name is Sam Shihab.
I'm Brian Burke.
And we're from the law firm of Sam Shihab and Associates. We are an immigration law firm that represent clients from all over the country and all over the world. And today we're going to talk about travel and preservation of the green card. Let's start with the basic rule.
Well, the basic rule is that when you get your green card, you're a permanent resident of the United States. Congratulations. And the U.S. government expects that you're going to maintain that indefinitely. However, if at any time they believe that you're not really intending to permanently live in the United States, they can consider your green card to be abandoned.
Abandonment is a concept that people associate it with time spent outside the U.S. While time spent outside the United States is relevant, the most important thing about abandonment is your intent. You could easily abandon your permanent residency for a lot shorter period. For example, you just picked up stuff, closed your accounts, and completely left the country. You've abandoned it. It does not require a timeline. However, the government gives us, Brian, timelines to guide themselves and us with the process.
When they start asking questions,
Yes. So let's go over the basic rule real quickly. The basic rule, the government expects you will maintain your residency in the United States permanently. If they do not believe you reside in the U.S., your green card could be considered abandoned. One important rule to remember is abandonment is an intent, has nothing to do with time. The timeline specified that we will be discussing shortly is only a guide that the government used to determine abandonments. Now, that we have talked about timelines, let's talk about the first timeline, which is less than 180-day absence from the U.S.
Yeah, this is an easy one because less than 180 days is generally not going to be a problem. So if you leave the country for less than 180 days, the government is typically not going to question you about abandonment of your permanent residence. However, longer periods of time abroad with, short periods of time in the United States could draw their attention. So the classic example of that is, you leave for 5.5 months and come back for 2 weeks to preserve your permanent residence and leave for another 5.5 months, never being gone for more than 6 months. They could have issue with that.
The government would say that, practically speaking, you're living outside the United States. You're just coming here to satisfy the 6 months rule. And we've talked about the fact that abandonment is an intent, and the government can draw an intent from consistent absence, even though you're less than 6 months every time you leave the country.
Indeed.
Let's talk about more than 180 day, but less than 1 year, or really 180 day to less than 1 year.
Yeah, that creates what we would call a rebuttable presumption of abandonment. And basically, that's something you can overcome. They're going to say, whoa, you've been gone for more than 6 months, less than a year. We believe you've abandoned your permanent residence. Tell us why you haven't.
And that's where you present your factors. So there are factors you can present to rebut that presumption. And these factors could be ownership of property, Brian, U.S. employment and evidence of U.S. employment, tax, filing tax returns in the U.S., kids in the school, the purpose of your temporary absence, 401k plan, ownership of houses.
For me, it's anything you can point to that says, hey, I may have left the country, but my life, where I really was, I was always intending to come back here. The U.S. was always my home. I was just doing some temporary travel abroad.
Yes. So before we jump into the big one, which is the absence more than 1 year, let's recap very quickly. So, Brian, you want to do that one?
Yeah, sure. So less than 180 days abroad generally won't be a problem unless there's repeated trips of long duration. So again, just because you come back to the United States, once every less than 6 months, it doesn't mean you've maintained your permanent residence, and you might face difficulty from customs officials when they catch on to that. Less than 1 year, but more than 180 days, that's when you hit the rebuttable presumption of abandonment. And this is when we talk about those factors to overcome that. It's property in the United States, U.S. employment or being dispatched by a U.S. employer to an assignment abroad, filing your taxes in the United States, leaving your kids or other family members, in the United States waiting for you to come back. Anything you can show them just that says, hey, I may have left temporarily, but my home was in the United States the whole time. I didn't abandon my life here.
Yes. Now let's talk about the big one. Absence for more than 1 year. Now, if there's an absence for more than 1 year, there is a presumption of abandonment, and you must go to the U.S. consulate and apply for
what is called an SB1, or also a returning resident visa. And that is a formal visa application to the consulate. I know when you're a permanent resident, you think you're done with those, but you go back to the consulate and you say, hey, I was a permanent resident, I left for too long, please take me back. And you have to sort of explain to them why you were still a permanent resident. And this is things like, the factors we discussed before, property, filing your taxes in the United States, having your life there. And also what is useful are other explanations to explain why the travel abroad was for so long. So taking care of an ill relative or addressing to some sort of important matter abroad that really required you to be there, something they can understand.
When we represent clients on SB1 applications, it's very critical that your presentation is very organized, very exhibited, with evidence to support your position. And if you do a good job presenting it, you should have a good luck in getting that SB1 visa approved.
Yeah.
Now, on the planning side,
so don't plan for an SB1 visa because there's no guarantee that that will be approved. But if you know that you're going to be on a long trip abroad, you can apply for what is called a reentry permit. And a reentry permit is an application you file before you leave the United States. It says, hey, I'm going to be leaving, I'm going to be coming back, and they'll give you a reentry permit for up to 2 years, which should allow you to come back to the United States during that 2-year period for which that reentry permit is valid.
Let's recap. Absence for more than 1 year, there is a presumption of abandonment. Now, if you find yourself in that situation, if you spend more than 1 year abroad and did not have a reentry permit, you can apply for a returning resident visa called SB1 from the U.S. consulate. You must establish that your trip abroad was temporary and that you have continued to maintain your U.S. residency to overcome that presumption. Now, with regarding to pre-planning, you could apply for a re-entry permit before you travel. A re-entry permit is valid for up to 2 years. Your green card should remain valid so long as you travel back to the U.S. during re-entry permit validity period. Please remember that the material presented herein is for informational purposes only. There is no attorney-client relationship is established, and always consult an attorney before filing a case or making any immigration law-related decision. Thank you from the law firm of Sam Shihab and Associates.